to not be concerned about 5-minute timeline.
Yeah.
You know what I mean? I go for, even if it's maybe not 10, but like a nice proper discussion.
Yeah.
You know?
Hello everyone, Harun here. Welcome to the Matter for the week. Of course, this week we would talk about Sodomy 2, the decision by the federal court in the Anwar Ibrahim second case for sodomy. Basically, I would like to discuss the turning points in the judgment, which form the core of the basis for the conviction of Anwar Ibrahim. Rather early in the judgment, I thought it was strange for the Chief Justice to pronounce that consent is not an ingredient in sodomy offence. There is a correct statement of law, but I find it rather strange because the police report clearly says that Saiful was forced. However, the evidence somehow show arguably otherwise, because the evidence show that he carried KY jelly with him. He wore a towel while waiting in the room when Anwar Ibrahim was bathing. So those evidence go against force. So when the court pronounced really early in the judgment, consent is not an ingredient in sodomy offence, I thought that would set the tone to imply that the sodomy which took place was non-consensual, although there wasn't any finding of fact to that effect. Now, the first turning point in the judgment was, of course, when the court held without reservation that Saiful was a credible witness. To me, once the court held that Saiful was a credible witness, Anwar Ibrahim's defense was gone. It means that the court will accept in totality, what Saiful say had happened in the room between both of them. Then the second turning point after that was when the court held that evidence which was obtained illegally is still admissible and can be used by the court if that evidence is relevant to the case. This is in respect of those evidence obtained when Anwar Ibrahim was detained in the cell for one night, where they gave him a towel, a toothbrush, and the next morning they took the DNA sample from his hair, from the towel and also from the toothbrush. Now this is important because without that evidence, without that sample obtained that night, there would not be any comparative sample to compare with the DNA obtained from Saiful's anus. And in this respect, I have to stress that the court had made the correct pronouncement of law, i.e. in Malaysia or even in England, evidence which is obtained illegally may be used by the court if it is relevant to the case. So once this is decided upon, that means there existed a comparative DNA which could be used to compare with the DNA obtained from Saiful's anus. Once compared, it was found that the DNA obtained from Mr. A in the lockup is identical with the DNA obtained from Saiful's anus and the semen. So with that, Anwar's fate was sealed. The third turning point is, of course, when the court held that political conspiracy was not supported by any kind of evidence. Now, this is the point. I've always maintained throughout the trial, Anwar had made a grave mistake. He chose not to go to the witness box, take oath, and give testimony under oath, open himself for cross-examination. He did not do that. Instead, he chose to stand in the dock and make a statement from the dock. Now, a statement from the dock is not under oath, and you can practically say anything you like. You can say, it's not me, an alien did it, because you are not going to be cross-examined. There is no way for the court to test or verify your statement. And that is why, in any criminal trial, a statement from the dock is always viewed with a lot of doubt as to the veracity, as to the weight, and as to the credibility. I thought when he made the statement from the dock, that was a big mistake. And fair enough, his so-called defense of political conspiracy become something just like some political speech. And fair enough, the court rejected it outright. And with that, he's got no leg to stand on, and he was convicted. The last point that I would like to say about this case, and this is really important to me, in fact, it is far more important than the conviction itself, that is the sentencing, i.e. the penalty handed to Anwar Ibrahim, 5 years for sodomy. I thought it was very harsh, unprecedented. You know, we have all sorts of other more serious offence against the state. You know, K. Toyo was convicted for abusing his power as a Menteri Besar. That was an offence against the state. And he was given a 1-year sentence. There was a statutory rape where an underage girl was raped, of course with consent, but still it was a statutory rape. And the perpetrator was set free with a bond of good behaviour, apparently because he has a bright future as a national bowler. That was a statutory rape, also an offence against the state. It is, you know, that offence is there to protect underage girls, and yet he was set free on a bond of good behaviour. And here we have a sodomy where force was not established. If it was a consensual act, it was a private offence between two consenting adults, and he got 5 years. I thought it is really harsh. I hope this penalty, this punishment, does not reflect the priority set by our society for its behaviours and acts in the future. So that's it. Thank you very much for this week. Thank you.